Hey y'all, can y'all hear me? Good. All right. Really quick, I wanted to get in real quick before you guys head over to Miss Whitney for the. I'm sorry for the reading, child. My man's so bad. I'm just gonna say, hey to everybody that comes through. I'm trying to speed it up so I won't have you. I just want to make sure that we kind of are on the same page when it comes to the defenseless defense, as well as I'm gonna try if I can, depending on um, how long it takes me to kind of explain the defense again, because man, I always need to want to make sure that we are, you know, thinking about things as we go, because ultimately, no matter what side you're on, you really don't want any surprises, and you want to know what it takes to find someone guilty, or innocent, you know. And it's basically they use the same metrics to do either one, and that's just in my opinion. Can y'all hear me okay? Right. I'm going to edit out that video, trim it out, figure out to do that, and then I'm going to, then it's going to publish itself. But yeah, that's crazy. And that was the Aaliyah video. So now I'm scared to even play music because it's like, I don't know if they're blocking anything, any songs or anything like that that just have something to do with R. Kelly or Leo, anything of surrounding around R. Kelly. I don't know what the hell is going on, but it's blocked for that song. So oh no, like I said the other night, it was blocked for that R. Kelly song, R. Kelly and Jay-Z song. So again, so this morning, we've spent the better part of the morning of that live video, um, trying to talk about defense, the defense's defense, right? And what I was trying to convey to Robert is that it's more than just the prosecution presenting the evidence to the jury, and or the defense coming up and saying, okay, well, my client is innocent, he ain't do it, whatever, and then that's supposed to be enough for the jury to decide on the case. That's not how it goes. That's why they have a jury charge, aka the jury's instruction, and it tells you what you must need, what do you need in order to find in a verdict of guilty, right? So Atmos got up and God bless his heart, and he confirmed. And this is, I didn't know for sure. I mean, I just took a guess, well, an educated guess about what the defensive strategy was. I didn't know that because we just got that transcript from day one, where the opening statements were made. So I didn't know what the defense had said in its opening statement, but it confirmed the defense that I was pretty sure they were using again, which was the justification defense, which is an exculpatory defense, and it's something one that is a sister to the one that I came up with when I was talking about diminished capacity. They are using, and I hate for this to sound like a broken record, but apparently some of us, you know, need to get it again so you can have it in your head. They're using the excuse, right? They're saying, yes, I did it, but here's the reason why I did it. And with that focus, with that defense, it places the focus on the defendant rather than the actual crime itself. And a defense doesn't have to be just one facet, right? It could be, they can, that could be the main defense, and they can add things onto it. It's something like, what they say, having a kitchen sink or kitchen and throwing everything at the jury and hoping something sticks, something enough that raise reasonable doubt. Because remember, the defense have to raise reasonable doubt. The prosecution has to convict beyond a reasonable doubt. That's how that works. Okay? So, the defense has to put their defense before the jury. That's what they're going to use to try to get their client off. Not just by simply just saying, the evidence, not by just going by, okay, the prosecution just presenting their evidence and that should be enough to convict. What's in the indictment should be enough to convict and whatever. It don't work that way. If it worked that way, then we wouldn't need a trial. So they do have a defense, and that's the one they're using. Whether you agree with it or not, whether you understand it or not, we're talking about the law. It's not your understanding. Your understanding is not going to convict or find him not guilty. It is the law and the procedure. That's why they took the time to lay out that elaborate jury charge or instruction. I would guess that at some point the defense or the judge, one of them or both, will point out that the prosecution have to prove every element of the crime in order to find someone guilty of that particular crime, right? So they can use multiple defenses, but the main defense they're using is that excuse defense because, like I said, that was a justifiable defense was like the only way that they can address the evidence. You can't tell the jury not to look at the evidence. I mean, may like the evidence doesn't exist. You can't say that if your client didn't do the stuff because evidence exists. So you just can't do that. I promise. I promise you, I'm right. Okay, 'cause I didn't even know that they had said any of that in the defense's opening statement because I haven't read it, and they are acknowledging that hey, things happen, but there's a reason why it happened. They're putting the blame on everyone. Looks like except the defendant. They're saying that the girls lie about their age, the girls stalked them. I mean, it's just different things. That's part of their defense. You understand what I'm saying? What it do, Atlas? So, just real quick, I want to look at those things before you go over to Miss Whitney. Let me see, where was I? Where's it got there? Document. Okay, hold on, y'all. Try to share my screen here. Other than that, I hope y'all having a blessed Sunday. Let me see. Okay. Let me see how many pages real quick. Let's see if y'all can see this. Real quick. This is in the jury's charge, right? The instruction. I put a copy of it, not a, the where you can click on it and get it. If you guys want me to email it to you or what have you, I'm gonna put my email in here. Oh yeah, I forgot. Darn. Thank you, Valencia. I keep forgetting to run this banner. I'm going to put my email in here, right? Make sure y'all email me and I can give you a copy of this. Because if you think that it's just as simple as they should be able to read the indictment, look at the evidence, and it could, no, that's not how it works. All right, that's my email. I will email you a copy of this jury charge. So let me go and read. Okay, now, all right. I'll start here with the preliminary statement. It says, pursuant to Rule 30 of the Federal Rule of Criminal Procedure, the government respectfully requests that the court include the following instructions in its charge to the jury. In addition, the government requests to leave to offer additional instructions as they become necessary during the course of the trial. The government respectfully requests that copies of the third superseding indictment and the jury instruction be provided to the jurors during their deliberations. Okay? All right. I'm not going to read request number one. All right? Because it says the government respectfully requests that the court charge the jury in its usual manner on the following subjects. And it's just pretty much outlined, laying like the rule of the court and stipulations and deliberations, things of that nature. Pretty much, you know, housekeeping items as it pertains to the course of the trial, right? But request number two, right? The indictment. It says the defendant is formally charged in an indictment. As I instructed you at the outset of this case, an indictment is a charge or accusation. The indictment in this case contains 9 separate counts, on each of which you will be called upon to render a separate verdict. Okay? Request number request number 3, I'm sorry. Knowingly and intentionally. All of the charges implicate the concepts of knowledge and intent. As a general rule, the law holds individuals accountable only for conduct in which they intentionally engage. Thus, before you can find the defendant guilty of the crimes charged, you must be satisfied he was acting knowingly or intentionally. Okay, I think a couple of lives back, we were talking about, well, actually, a little bit. We talked about it a little bit this morning about premeditation. Hold on, I got it written right here. About the premeditation, about he knew about the crimes and the pattern of we were talking about the pattern of writing the letters, right? That's the pattern that he had with some of the girls, that they were writing letters with all kinds of accusations and stuff, implementing themselves in crimes or talking about their parents or what have you, right? You're familiar with what I'm talking about. All right. So, and I'm sorry, this is a first read for me with this, but they pretty much all kinds of contain the same information for criminal cases. All right. It says, the second paragraph, it says, a person acts knowingly if he acts voluntarily and intentionally, not because of ignorance, mistake, or accident. Okay. So right there, the prosecutor is trying to rule out that the jury shouldn't use ignorance of the law, I made a mistake, or it was an accident. So that's kind of trying to get ahead of that justifiable defense that the defense is using, that defense of excuse. And we read, all right, a person acts intentionally if he acts with the specific intent to do something the law forbids. The person need not to be aware of the specific law or rule that his conduct may be violating, but he must act with the specific intent to do whatever it is the law forbids. All right. So that can speak to the consent, right? Because it's saying, again, it says the person need not to be aware of the specific law or rule that his conduct may be violated, but he must act with the specific intent to do whatever it is the law forbids. Next, it says these issues of knowledge and intent require you to make a determination about a defendant's state of mind. Remember, that's called mens rea, something that rarely can be proved directly. All right, this is written really, really well. A wise and careful consideration of all the circumstances before you, however, may permit you to make a determination as to a defendant's state of mind. Indeed, in your everyday affairs, you are frequently called upon to determine a person's state of mind from his words and actions in the given circumstances. You're asked to do the same here. Remember, I was telling you guys about mens rea, which is the mind, and actus reus, which is the behavior, the conduct. Those two things are under consideration when determining someone's innocence or guilt. Okay. All right. Number 4, aiding and abetting and willful causation. Remember when I told you causation, also known as a but for, causation is the cause and effect. So they will say R. Kelly is the cause, his behavior, his conduct was the effect, right? So that's the end results. And the but for means that but for the girl, the ladies, or I'll say the accusers, communication or interaction with R. Kelly, none of these crimes would have occurred. That's the theory of but for, right? All right, and we read. Let's see. Many of the racketeering acts in count 1 and certain of the other counts charge the defendant with aiding and abetting or willfully causing certain crimes. It is not necessary to find that the defendant personally committed those crimes as long as the government proves he aided and abetted or willfully caused another person to do so. That's the RICO part of it, right? This is so because under the law, a person who aids or abets or willfully causes another to commit an offense is just as guilty of that offense as if he committed it himself. So remember the 3 B's, right, that we have. It's at the behest of R. Kelly, on behalf of R. Kelly, and R. Kelly is the one that would benefit. All right, and we read. Let's see. With regard to aiding and abetting under federal law, the aiding and abetting statute is Title 18 of the USC Section 2A, which provides that whoever commits an offense against the United States or aids or abets or counsels, commands or induces or procures its commission is punishable as a principle. Therefore, you may find the defendant guilty of an offense charge if you find beyond a reasonable doubt. Remember, I said prosecution need to prove beyond a reasonable doubt. The defense have to prove reasonable doubt in order to get a verdict of not guilty. Okay, so it says the government has proven that another person actually. Okay, let me restart from the beginning of that. Therefore, you may find the defendant guilty of an offense charge if you find beyond a reasonable doubt that the government has proven that another person actually committed the offense with which the defendant is charged, and that that the defendant aided or abetted that person in the commission of the offense. In order to find the defendant guilty of aiding and abetting a crime, you must find that some person did actually commit the crime charged. Okay, in order to find the defendant guilty of aiding and abetting of a crime, you must first find some person did actually commit the crime charged. Obviously, no one can be convicted of aiding and abetting the criminal act of another if no crime was committed by the other person in the first place. But if you do find that a crime was committed, then you must consider whether the defendant aided or abetted the commission of that crime. In order to aid and abet another to commit a crime, it is necessary that the defendant knowingly associate himself in some way with the crime, and that he participate in the crime by doing some act to help make the crime succeed. To establish that the defendant knowingly associated himself with the crime, the government must establish that the defendant knew and intended that the crime charge would be committed. To establish the defendant participated in the commission of the crime, the government must prove that the defendant engaged in some affirmative conduct to avert act for the specific purpose of bringing about that crime. The mere presence of the defendant where a crime is being committed, even coupled with knowledge by the defendant that a crime is being committed, or merely associating with others who were committing a crime, is not sufficient to establish aiding and abetting. One who has no knowledge that a crime is being committed or is about to be committed, but inadvertently does something that aids in the commission of that crime is not an an aider or abettor. An aider and abettor must know that the crime is being committed and act in a way that is intended to bring about the success of the criminal venture. To determine whether the defendant aided and abetted the commission of a particular crimes or caused the commission of them, ask yourself these questions. First, did he participate in the crime charged as something he wished to bring about? Second, did he associate himself with the criminal venture knowingly and willfully? Third, did he seek by his actions to make the criminal venture succeed? If the defendant did all of these things, then he is an aider and abettor, and therefore guilty of the offense. If, on the other hand, your answer to any of those questions is no, then the defendant is not an aider and abettor, and you must not find him guilty. Okay, so I'm going to. Oh, let me knock this out real quick. With regards to willful causation under federal law, Section 2B, of Title 18 of the USC provides that whomever willfully causes an act to be done, which is if directly performed by him or another would be an offense against the United States, is punishable as a principle. In order to find a defendant guilty of an offense charged under this statute, you must first find that another person has committed the acts constituting the offense charged. Second, you must find that the defendant had a mental state required to violate the offense charge. Third, you must find that the defendant intentionally caused another to commit the requisite act. I further instruct you that to convict a defendant of aiding and abetting or willfully causing an offense under federal law, you must unanimously, agree that the government has proven beyond a reasonable doubt either that the defendant aided and abetted the commission of the offense or that the defendant willfully caused the commission of the offense. In other words, all 12 of you must agree on either aiding and abetting or willfully causing. It is not sufficient that some of you find the defendant aided and abetted the commission of the offense, while others find that the defendant willfully caused the commission of the offense. All right, so I'll stop there on page 9, which is what I wanted to do the first 9 pages anyway. So it works out perfectly. And I'll come back over here. So let me ask you this. Did y'all so do y'all understand what I'm saying about the defense that one they have one, okay? And two, it's not as easy as here's the indictment, here's the evidence. Based on the preponderance of the evidence, you got to find him guilty, right? It's not that easy. It's not as simple as that. It as you can see, as that document that I just read, that's just 9 pages of it. It's great detail that goes into finding someone innocent or guilty, right? They give you the instructions for what you must use to find someone innocent or guilty. Right. So let me take this down. So yes, I just want to make sure, we keep that in mind, and we can come back to it, and it gives you a deeper perspective of what they're asking the jury to use. And the defense is not going to, most likely, is not going to use the same defense for every particular charge. It can't. I don't see how they can, because the elements of the crime provides that the defendant acts differently pretty much on every crime. Some of them is him knowing, some of him is him participating, some is both. Either way it goes, in that instruction it says whether he knew about it, he participated, or any of that you should find him guilty of that crime. That was drafted up really, really well, because it ultimately places the defense in a box when it comes to a lot of these crimes. Because it's not saying, okay, you can only find somebody guilty of murder if you put the gun, if the person had the gun, shot the person, and that's the case. No, it's pretty much saying, well, hell, if you was around, I mean, R. Kelly could have been around. So it's kind of, it's really kind of countering that excuse defense because they're saying, well, no. I take it back. The excuse when it comes to, you know how they're saying like it was the other people that was getting getting the ladies and well the girls at the time if they reminds getting the girls and it was them that was it was other people that was passing the phone number off and it was the runners and all those people. Well, the way that document is written is saying that well regardless of the person, somebody's giving the numbers and whatever, they're saying that if R. Kelly knew about it and participating from it, he benefited from it, he should be held responsible. He should be criminally liable for those particular acts. So they really did, kind of box them in. Of course, I want to see how that, how the defense counters it. But yet, the whole main goal is to make sure that the jury understand your position and the story that you're trying to lay out on either side. So that is what I wanted to tell y'all real quick. Hopefully, I'll get to come back depending on the timing and stuff like that. Hopefully I'll be able to jump in and help Atmos with some of that reading and witness some of that reading Diva, whoever's reading. Maybe I can jump in and knock out a few pages to get it down. But yeah, today is Tier's birthday. So y'all to wish her happy birthday. And that's all I want. So y'all let me know if y'all can give me a couple of yes or thumbs up or whatever in the chat. If y'all understand that what the main defense seem to be. And that is justifying it. That is saying that, yeah, he did it, but here's why. And it's, considered a excuse defense. You got it? Y'all got it? Thanks, Angie. You had to discuss the jury counters. Yes. Okay. All right. All right. So let me go ahead and let y'all get on out of here. And you can go to Miss Whitney DTV. Okay, I don't agree with you. Right. Okay, Jennifer. That's fine. Yeah, I mean, hey, they had to come up with something. They can't say, hey, don't look at that evidence. They had to come up with something because if not, it wouldn't make any sense. Let me see. Next minute. Oh, no problem. Yes, it reads. I was like, what is Vince's head? All right. Okay. Y'all get it? Y'all get it. All right. Honey, we just have to make sure we all get it. All right. Okay, y'all. So, hopefully I will see y'all over at Miss Whitney. I got a few things to do, but hopefully I'll jump over there and Miss Whitney. And make sure if y'all can try to figure out, find out what page she left off on. All right, y'all. Okay, let's see. We will be reading day 4 of the transcripts today on 6506. Okay. All right, Dom Kane. All right. It is all good, folks. But thanks, everybody. And see, look at God. Look at how everybody working together. Look at God. That's what I'm talking about. There ain't nothing wrong with working together, honey. To get to the what? A common goal. Finding out what the hell actually happened. Because as you see, the news is reporting largely one side of what's going on. We need to know what the other side is. Because you're gonna be, you know, in shock if something shit happen and you wasn't expecting it. You thinking if you on one side, you thinking everything is going good, and somebody hit you from behind, you're gonna be crying. All right, y'all. Thank you, y'all. All right. Thanks to the host and hostess and the guests and everybody else. Till next time, peace out.